Welcome. The Navigating Florida House Bill 1159. This is a panel discussion that concerns a law that was recently passed by the legislature and signed by the governor. In particular, we're going to look at section number 1 that is associated with trimming, pruning, and removal of trees on residential properties. The law itself did not define several key terms, and this has caused a great deal of confusion and misrepresentation about what the law actually means, how it might be interpreted, how it might be incorporated in local government and county government programs. Today, the panel will address 10 questions, 8 questions actually, from more than 70 that had been sent in originally. We tried to pick out the most pertinent questions to get the panel to answer, but also we chose questions that themselves, the panelists who are experts in their own field, were likely to be able to answer with some authority. Some of the questions that were sent in, such as, what is the state government's role in this? Will the different departments in the state government oversee this law eventually? That's not within our purview to answer, but we hope that we will take, when we take those large group of questions and farm them out to experts across the state, that we will be able to get answers to these questions. And they will be posted online. This particular panel discussion is also being recorded and it's being posted online, and we expect to have both the recording and the document up by the end of tomorrow. Perhaps not all the answers to the questions, but most of the questions that are done. So I want to introduce, my name is Rob Northrop, and I'm going to act as the moderator and sit down here just 2 seconds. I want to introduce our panelists. 4 of them are here with us. One of them is on the east coast of Florida and is online with us, and we'll be answering questions too. First, Norm Easey. Many of us know Norm from work in arboriculture and forestry, decades of experience. Got the great view group. He's the CEO of the Florida chapter of the International Society of Arboriculture, obviously a key part of what's going to happen with the implementation of this law. Jeff Van Treese is a lawyer, but also has a PhD, and I think he studied tree risk, right? Yes. Tree risk. So Jeff has been gracious enough to come up and spend the afternoon with us, address some of the legal questions, but also bring his expertise to bear on tree risk within the legal framework. Dr. Andrew Koeser is an assistant professor of environmental horticulture, in particular arboriculture. He's a board certified arborist, by the way, as is Norm, which I forgot to mention. But Andrew's particular research interest is tree risk. And he's recognized in many parts of the world as being one of the preeminent experts in that subject. And to my immediate left is Joe Gross. Joe Gross is the program manager for the natural resources section of Hillsborough County's government. And Joe's going to provide us with some good insights on how this particular government in this county is addressing the law and incorporating it into its program. The final person we have who is not here with us, unfortunately, but whom you will see on your screens when she does answer her questions, is Emily Mahoney. Emily Mahoney is a landscape architect. She's the past president of the the American Society of Landscape Architects Florida chapter, and the chair of their government's affairs committee. So those are our panelists. The way we're going to work this is each question will be addressed to an individual panelist who we believe had the greatest level of expertise for that question. They'll get 5 minutes to answer the question. They've got the questions ahead of time, by the way. 5 minutes to answer the question, and then each panelist will have 2 minutes to say whatever they want about that particular question. And that's how we'll move through this session. So we're going to start out with just a real quick, I'm going to read you the section that they're talking about from the 163.045 of the Florida statutes. It's created to read tree pruning, trimming, or for removal on residential property. Section 1, Florida statutes. Number 1, a local government may not require a notice, application, approval, permit, fee, or mitigation for the pruning, trimming, or removal of a tree on residential property if the property owner obtains documentation from an arborist certified by the International Society of Arboriculture or a Florida licensed landscape architect that the tree presents a danger to persons or property. Number 2 is a local government may not require a property owner to replant a tree that was pruned, trimmed, or removed in accordance with this section. And number 3, this section does not apply to the exercise of specifically delegated authority for mangrove protection pursuant to so-and-so and such, and most of us are familiar with that. So I'm going to start off. Question number 1 will be addressed to Andrew Koeser, and that question is, what does the current science say about our ability to define the danger a tree poses to persons or property?
Okay, well, thank you, Rob. So the word danger came up, and that was, if anyone read the law, you probably mean what danger means and what does it mean in practice. These questions, by the way, these are the most common questions we got from many people, and that's why we're pointing on this, and that's why this one is here right now. I sent this out and some other questions to some other folks, some colleagues that I really trust, like Tom Smiley, Jerry Bond, some experts from across in Australia and UK, Sharon Lilly, all the folks that worked on many of the guides that we have in our industry. This is the Tree Risk Assessment Manual for the ISA Tree Risk Assessment Qualification. And this is the older version of the BMP. My students stole the newer version. I think Norm has the newer version. But this is, I'll be referring to this document a lot when I talk. So science is what I work on. That's my job, and that's what I'm going to try to stick to today. In general, we don't really use the word danger or hazard in the industry anymore because it has connotations that we want to avoid. You know, everything that can cause harm is a potential hazard. You know, a pool in your backyard, a tree, anything that can potentially harm you, but we want to qualify that or quantify that and nuance it when we talk about risk. Because risk is the likelihood that that's going to occur. You know, and when we talk about risk, we talk about acceptable risk and risk that is fine, that we can deal with on a daily basis. When we do risk assessment, we talk about the likelihood that a person will get struck by a tree or be impacted by a tree, or services will be disrupted or property will be damaged. We talk about the likelihood that a tree that will fail or break. And we talk about the consequences of that failure. And I'll talk to the research that speaks to those 3 inputs in a little bit. You know, when you want to assess this, we want to know, are we really risk assessing trees correctly? Are we being accurate? Or are we just all following the training and we're all off target? There's a difference between accuracy and precision. Well, we do have some research that kind of speaks to where we are with this. My student, Ryan Klein, when he looked at the likelihood of impact and can we actually guess if someone's going to be present on their tree when it fails. And he found that there's a correlation between visual ratings when you see the site with an actual traffic counting. So that's good to know. Then we break it apart again. Likelihood of failure, that's probably the hardest thing that we know how to assess. Like, will a tree fail within a given amount of time, right? It's kind of almost like looking at the crystal ball a little bit. Well, there's only 2 studies that looked at this before. And one was in 1995 by Hickman et al. They looked at nearly 700 oaks in California and came back 6 years later to see which failed. And they found that in their risk assessment rating system, which they made up themselves, they were able to predict 83% of the trees that were still standing and 78% of the trees that failed. So that's pretty decent. That's better than most like sports betting models out there, right? And then recently, this is unpublished research, but this is something I'm gonna get out shortly. We looked at Hurricane Matthew and the storm damage that occurred after Hurricane Matthew swept the east coast of Florida and South Carolina and Georgia, we found that certified arborists and track qualified tree risk assessment qualified arborists were able to identify the worst of the worst trees, and those failed 95% of the time, right? So that's pretty good. We're pretty good at seeing gnarly trees that are going to fail in a storm. And then right now I'm looking at consequences of failure. That is, will something happen if the tree fails on a target? And we're moderately accurate with gauging size. The size matters for this, and we're working on improving that. One thing I do want to talk about is the training, and there's training that goes in this law. We found that in many cases, certified arborists perform better than non-certified arborists. So there's evidence to back up that part of the law. For example, when people were rating occupancy, there was really no difference between certified arborists and non-certified arborists. But when we looked at failure potential, that was something that certified arborists were a little bit better at gauging. They were also more conservative in their ratings, and they're less likely to cut down a tree out of fear than a non-certified arborist. Also, arborists with the qualification, they're even more accurate when it comes to gauging like size of parts that are going to fail and the likelihood of them going to fail, and they are they're much less likely than even a certified arborist to cut down a tree out of fear. So because of that, if it's ever revised, I would argue that maybe the track qualification is something that maybe there's some research to back up and then maybe look at for improving the law. So I do have a list of references. I will have those all on the document that we were putting on Google Docs. So, and my time is up. So
Thank you. Norm? So everybody gets a couple of minutes to talk about that particular question.
Dr. Koeser answered the question fairly. I think, though, that there's a distinction in law that we need to address, and that is who is responsible for this activity. And as I read the law and as I read and understand track, it's an activity that takes place between the arborist and the tree owner. And it's the tree owner that ultimately decides the level of risk that they're willing to tolerate. What the arborist does is they come up with a risk rating. And that risk rating has a meaning to it. The meaning is explained to the homeowner, and the homeowner ultimately decides if that risk level is something that they can live with or not. And that's how our system works. And to the extent that it fits in this particular model, I think only time will tell.
Jen?
Speak up next time. Try to speak up a little more.
I have a quick question if you
No,
they don't give me time.
Please mute the microphone. Thank you.
This kind of ties into my question, so I'll just kind of, the next question coming up, so I'll just kind of keep it brief. But I'd say that getting sort of piggybacking on what Norm was saying, what Norm is kind of getting at is what we call subjective standard, which is the individual homeowner comfortable with the risk? Whereas generally what laws try to establish are objective standards, which is what either a reasonable person or the law is going to recognize as an acceptable level of risk, or whether something's unduly dangerous or not unduly dangerous. Like Andrew said, anything's dangerous to some level. It's a question of how much danger are we willing to accept. And so the fact that the statute doesn't define dangerous, which I'm going to get into in a minute, can become quite problematic because different people have different definitions of dangerous, and then it's a question of who determines what's dangerous and what's not dangerous. So there's going to be a lot of room for conflict here.
Just to kind of reiterate what's been said, the big issue for us is the degree of danger. That's one that we are grappling with. Our jurisdiction has dealt with emergency permits for years. Typically that's done when photos are sent to us, it's obvious that we have a danger, an imminent danger. We waive the fees, we look at the photos, and we issue the permit. And because in line with this statute, the intent is to try to avoid any damage to property or individuals. But that's the type of condition that the contractor isn't going to leave the property until it's mitigated, until it's addressed. So is that the danger we're dealing with? Or is it something, another definition, which I think we're going to get into the next question.
Thank you. The next question is for Jeff and Treese. By the way, great name. Sorry. Not very special. But Jeff, of course, is a lawyer and an expert on free risk. So the question is there a legal definition for the term dangerous?
Well, that's a great question. The answer is no. There's no statutory definition in this framework that tells us what dangerous is, and that's going to be very problematic because that's what it's going to be fought over when this goes to court, which it inevitably will. There's the term. What we generally do in virtually all jurisdictions, including Florida, is that if the term's not defined in statute, we look to the sort of the everyday common English use of that word. And so what sometimes judges will do is they'll look at something that's called Black's Law Dictionary. And they often cite Black Law's Dictionary to define something. And so I thought I looked it up, and the Black's Law Dictionary defines the word dangerous as something that can cause loss or injury. So that's a very nebulous definition, and it's one that doesn't take into account the degree of risk or the probability of loss, right? It's just anything that can cause a loss or injury is dangerous. So if you look up Webster's dictionary, it's defined as something that is likely to cause problems or have adverse consequences. So that's generally how we define dangerous in everyday usage. So that's kind of amorphous, right? So it's a question of, when we look at risk, are we just looking at the risk of a tree failing? Or might there be other dimensions of risk? So, for example, I've done research on the building statistical models for the likelihood of a car crashing into a tree if it's placed in a road on the side of a road shoulder or a roadway median. So is that dangerous, right? And how do we calculate that? And how much proof is necessary in order to determine that something's dangerous? So if somebody, if an arborist goes to a tree, looks at a tree and uses a risk hazard rating in one of these books, right? For example, these texts are not referenced in the statute either. Perhaps they should be, to at least provide some objective framework. But if they say, okay, this tree is dangerous, do they have to provide some explanation of why it's dangerous, right? And does a municipality, a city, or a county government, which passes ordinances as it relates to land use, something we generally call zoning, they can put conditions on land use, and many of those conditions relate to requiring permits in order to cut down trees, right? And there's a special section for mangroves which require additional permitting. But as far as this goes, are they going to be if an arborist deems a tree to be dangerous, can it be cut down without providing any proof, or can the city, I'm going to say city or county, require proof? Okay, that has yet to be determined. And another question is does the city or county, do they have the power to be dangerous themselves and interpret the statute themselves? And the answer generally is no. Okay, there's something that's called preemption. Preemption basically means that when the state passes a law, it will override or preempt any municipal ordinance that would conflict with that law. And it's basically, you can think of it like the state law trumps the city ordinance. And in fact, just the other day, I went and looked at the city of Tampa, for example. I was speaking to the city attorney, and their chapter 13, which deals with permitting for removing trees, has been removed actually in light of this law. So they're probably going to be redrafting that. But the question of what is dangerous and how much proof is needed. So if an arborist just have a piece of paper that has a picture of a tree and the word danger next to it with an exclamation point, Is that enough under this law, theoretically? That's not clear, right? So how is this determination going to be made? It's going to be made by a judge somewhere, or it might get what they call certified, where let's say our court system starts in circuit court, they say this is an issue of great public importance, needs to be certified. It goes to what's called the District Court of Appeals, then they interpret it, and then at that point it could either be certified to the Florida Supreme Court, or it could be, or you have two districts that disagree with each other. So the lack of definition in terms of dangerous, I think, is going to be very problematic. It will certainly lead to some extensive litigation, because there's a lot of money at stake with developers that are going to potentially be using this law for their benefit to attempt to remove trees or have them deemed dangerous. And if the city doesn't want them to do that, what is going to be their mechanism in terms of code enforcement, in terms of coming in and trying to prevent that tree from being removed? And is it reviewable? Is the arborist's opinion reviewable by a court? That's another question the statute doesn't really identify. So can a city come in and say, no, we disagree with this arborist's conclusion, we want a court to determine it? That's not really defined either. So lots of ambiguity in this statute.
Thanks a lot, Jeff. Emily, I want to turn it over to you first to address this idea of the term dangerous.
Well, we're sort of get into some of that in the next question. I'm not sure that I have too much to say, except I totally agree that it is not clarified what it means. And landscape architects are licensed to protect the health, safety, and welfare of the public. So dangerous is part of that equation, but there's a lot of opinion and undefined space in there.
Thank you. Norm?
So I have quite a bit to say, particular issue. Many of you know that ISA manages certification programs. And so when I read this bill, the first thing I thought of is there are certification programs that we have that are appropriate, and there are some that are really inappropriate. And nevertheless, the way the bill is written, some of those inappropriate credentials that we have are eligible to write these reports. So for example, the ISA manages a suite of certifications from tree worker, what we call our climber specialist credential. And those folks are tested on their ability to understand some science, some biology, but a great deal about working in trees and arborist safety. Nevertheless, it's a certification. And as it's defined in this bill, they are eligible to write these reports. ISA also manages our ISA certification program, our certified arborist program, that there are about 2,000 certified arborists in the state of Florida. And they do address risk assessment in this assessment. We do assess their ability to do risk assessment, but we do it at a fairly shallow level. The ISA Arborist Certification Program is a very broad program, and it looks at many topics that arborists have to deal with, risk assessment being one of them. But none of these individual topics do we test very deep. It's a very shallow look and examination into each of the various topics that arborists have to deal with. And then up from that, we have our board certified master arborist program. And that's an individual who has spent many years in the industry and can demonstrate a very high level of understanding of all of those aspects of arboriculture, including risk assessment. And even that credential does not go as deep as we go with our track qualification. TRAC stands for Tree Risk Assessment Qualification, and it is a very deep dive into understanding the tree risk assessment process, the mechanics, the biology, dealing with property owners. It is a very deep dive into risk assessment. And so with that understanding, you can see that there's some built-in problems with this bill as it's written. The most qualified is the track people, but because it's a qualification and not a certification, track individuals aren't even included in the language in this bill.
Thank you. That's very informative.
Yeah, so, yeah, and to Norm's point, you know, when we did one study on like what drives risk assessment, only the track arborists are looking beyond the tree. You know, they're looking at the site, they're looking at occupancy, they're looking to see if someone will even be affected by a tree that potential fail, and I think that training has done a lot for that. One thing I want to talk about is documentation. You know, I like Jeff's happy tree with a danger sign next to it. I think that's a pretty effective and efficient report if you just want to churn out reports. But, you know, I posed this question to the group of risk assessors that I talked to, and I pulled up this text from one of them who said, well, you know, some people said that they use the track form in here, which is, it's about a 30-minute form if you fill it out completely, you know. But this is some good guideline. These are some good guidelines that I got from one of my friends. For documentation, this person suggests what's the likelihood of failure and how is it determined? Having a few words to, you know, explaining why you came to that rating. What's the likelihood of impact of a target and how is that determined? The consequences of failure, the harm. So the parts of the matrices that go in this, just, you know, putting the rating down and explaining how you came to those points. What was the overall risk rating? How is it determined? And then what is your mitigation suggested? What actions do you think should be taken? And then he had a sixth thing was to characterize in a few words the primary interest of the tree's owner. Where are they coming from in the scenario? What, you know, is this a tree that they want to preserve, or is it a tree that they're afraid of already? Things like that will help you protect yourself as you're doing risk assessments for your job. So. And I'll put these online as well, but I think they're pretty good guidelines. And a very short, succinct way of documenting.
Thank you, Andrew. The next question will be addressed both by Emily and Norm, but I'm going to let Emily take the first crack at it. Emily, you know, does the Florida chapter of the American Society of Landscape Architects have a standardized methodology for determining if the tree is dangerous, and is that methodology consistent with a legal definition?
I think now that Norm has further described the arborist certification, I probably need to get a little more into landscape architects. The simple, straightforward answer is no, there's no standard methodology. We are licensed nationally. We take a national exam, and all 50 states have licensure for landscape architects, and then half of them have a special test for Florida. In no place that I've ever seen has specifically addressed tree risk management. What we are licensed is on health, safety, and welfare and protecting the public. So I'm thinking, you know, I'm sure there are landscape architects that are also arborists, but we're looking at a broad picture. If we get hired to come onto a site, you know, we can do preliminary looking at issues where the tree is placed relative to what could be affected, and some obvious issues. If this is critical, I think ethically, if you, the landscape architect, don't have the training to take it to the level it needs to be, then you get in and I would say a risk, the track arborist who can clarify that. So because we're licensed by the state, we are also disciplined by the state. So we would not, I mean, you would not do what you're not qualified to do. Does that help?
Norm?
So my last comments essentially explained how the arbor certification program works around the world. And your question, does the Florida chapter have? And obviously we don't, but we are affiliated with the International Society of Arboriculture. And so the International Society of Arboriculture does have an excellent program for assessing risk in trees. I mentioned that earlier, and that's our track program. And the way the program works is it is a exercise, as Andrew mentioned earlier. It takes about 30 minutes. It takes about 30 minutes for a trained track individual to go through the exercise. Going through it the first time is going to take considerably longer than that. When we looked at who's going to be eligible for track, we wanted to have people who are trained in trees, and so our eligibility to sit for track includes certified arborists. So if you have the arborist certification, you are automatically eligible to take the track credential. It's a 2.5-day course to learn a deep dive into tree risk assessment. And that process then assures that that certified arborist in that particular aspect of risk assessment understands a fairly deep level about the subject. There are people that come to that class that have a very deep understanding of risk assessment to begin with, but you don't know who they are until they go through this process and pass this test. So my admonition to both certified arborists and to the public about this subject is that there may be arborists out there who don't have the track qualification, who are every bit able to do these assessments credibly. They may exist, but you don't know it unless they have the track qualification. Then you know that they have passed an exam that demonstrates that they have the ability to assess risk in trees at a fairly high level. The other thing I want to say about this issue is that track is a program that works between the assessor, the arborist, and the tree owner. And that's where this law, this bill, may be problematic. And I'm pointing this out just because we're talking about potential problems. So the way this works is that the assessor, the arborist, assesses a tree, finds a defect, puts a risk rating on it, puts a risk rating on the entire tree, conveys that information to the tree owner. The tree owner then decides what level of risk are they willing to accept. So our risk ratings run from low, moderate, high, and extreme. And so depending on the circumstances, depending on the severity, depending on the likelihood, depending on all those factors, it gets rated. And then the tree owner decides whether that rating is acceptable for them or not, and they want to mitigate that branch or fix the problem, or if the problem can't be fixed with mitigation, then remove the tree. We train our track people, arborists, that's where your relationship with your client begins and ends, is that report, that recommendation to them. Here's the risk. We give them options for mitigating the risk. The last option they should ever receive from a track qualified arborist is remove the tree. That's one that they are trained will be the last option. And we will always take other measures to mitigate the risk before we get to remove. But it is ultimately up to the tree owner to decide what level of risk they will tolerate. And you need to know that it begins with low. If a tree exists, it is automatically given a low rating. You cannot go lower than low. And low does not mean zero. So you may come out with at the end of your assessment and give the tree a low rating. And that person may decide that low is still too high for them. I can't think of another example that works that I could give you, but recently we've had problems with Boeing Max 737 Max jets. And the industry has said the risk on the Boeing Max is low. Would I fly on one? I'm not so sure. There are instances when low is still not low enough. And so you need to be aware of that dynamic as it relates to this law.
Thank you very much. Joe, you want to?
I'll just say that after what we've heard, in a combination of your suggestion that track had been an element of this statute, and after the reassurance, I think you could have known that someone with track training has both knowledge as well as the right approach is desirable. Obviously, we don't have that. So we're not, in a local government standpoint, we can't even insist upon that track requirement in the state. So very frustrating.
Did that begin to comment?
Yeah, I just sort of reiterate, I like the idea of having track risk rating potentially be used in the statute. But like Norm said, you start with low. So if an arborist says it's a low risk, is that still a risk? Is that still dangerous under the statute? That's something that, again, will probably be subject to litigation. Andrew, have a comment?
Yeah, we're talking about the ISA BMP method of risk assessment, which is the basis of the track manual. It's the purple book right here. But there is no one method of risk assessment that's kind of endorsed by ISA. So if your city has its own method, that's still okay. I know that, I believe Tampa uses the meaning Clark said, so it's still applicable. And as long as it covers the core aspects of risk, as we defined earlier, that's what we're looking for. I think we did a survey though. If you're looking for something that's pretty much accepted by the industry, when we did a survey of all the programs in the United States that have urban forestry programs, the number one risk assessment method used was nothing. But the number two was the ISA BMP. So this is gaining a lot of ground, and it's gained a lot of favor among folks in governments. So,
Thank you. For our fourth question, we're going to address it initially to Joe Gross. How does legislation affect local government minimum code ordinances that already exist and require the replacement of buffer trees or other minimum code trees that were required on large single-family developments by code or or by development orders.
I'm gonna try to use my football coach voice, but I'm not much. So first, we appreciate being able to be on the panel and give the perspective of local government, but I need to make it very clear that we're one of 67 counties and one of hundreds of cities. So it's very important as a practitioner that each jurisdiction that you work in, especially as this thing evolves, are contacted and consulted before proceeding. Having said that, for instance, I know we talked about the city of Tampa a little bit, and they have a dangerous tree definition. And in that definition, they actually set some parameters. So whether it will withstand the preemption that's been mentioned, that time will tell. But going into that jurisdiction, you certainly want to be aware. Under our current guidelines, most often there is no planting requirement or mitigation on a tree that's in poor condition, which we would assume a dangerous tree would fall into that ranking. There are some exceptions, but now that compares with removal of a protected, non-dangerous tree, which can result in an inch-for-inch replacement. So quite a contrast between the two. Based on the new law as we've read it, removal of a dangerous tree would not require replacement. We don't think we don't extend that view to believe that zoning ordinances, as Jeff mentioned, zoning agreements, things have been put in place, for instance, to buffer maybe a neighborhood from an adjacent neighborhood that has requirements that there be a buffer in place and it meets certain density or certain opacity. By removal of a dangerous tree doesn't mean that that buffer can now be degraded and not still serve as it is required. It might just be approaching it from a different standpoint. But if we're just looking at removal is made and it's a dangerous tree, and we come in and then require replacement for it, as we read it now, the answer.
Thank you. Emily, do you have a comment on that? Emily, you there?
Oh, she's still muted. So.
Hey, Andrew.
No, I mean, it sounds like this law is pretty much preemptive, as you were saying, Jeff, and it's pretty encompassing. So that's what we're working with.
Yes, go ahead.
I think Emily emailed me yesterday, actually, and I owe you an email, Emily. But one of the things she raised, and it's a good issue to throw out, is that this statute is geared toward local government. It doesn't talk about homeowner associations, it doesn't talk about deed restrictions, it doesn't talk about covenants. And some of those are very restrictive when it comes to trees and tree replacement. So there still may be a mechanism coming from another direction to require replacement of trees that is not preempted by this statute.
Jeff, a comment?
Yeah, just building on what Joe said. That's true. Also, homeowner associations are not government entities, so it's not. That's essentially like a contract you have with a homeowner association. You would have an obligation to fulfill if that's the case. One thing I would it's interesting is about whether there has to be a required report. Now, the statute says that it essentially stops a city or county from requiring requiring a replanting of a tree or from requiring a permit for cutting down a tree if it's deemed to be hazardous. But it's silent as to whether the city can require a report on the subject. So, for example, if the city said, okay, before you cut down this dangerous tree, you have to give us notification, okay, not approval, the notification, okay, and then fill out in a report what is required, or rather fill out in a report, we're going to require you to say what the danger is, what the findings are. So the city might be able to require that a report beforehand. That's possible. The statute's silent as to whether they can. May not require notice application.
So right. You can.
Yeah, it can. You're right. So adult may not require a notice application. Yeah, so it does say that they can't require notice. beforehand. Yeah, so that's interesting. So, yeah, I was actually reading it as being silent on that issue, but, you know, could they require anything at all? Okay, they can't require notice in advance. Could they inspect it? Arguably, this is all going to take place in a vacuum, so the county might not have any means of even monitoring what's going on. So it'll be interesting.
Norm, got a comment?
I think it'll be interesting to see as the operative words, we just heard.
Yeah, the next question's coming to you. Many of the questions that we've received over the last 2 weeks had to do with clarification of the term residential as it pertains to the bill. And does residential mean single-family lots, or does it include multifamily condominiums, apartments, subdivisions as well?
Well, yes, the answer is, the general answer is yes. Residential is going to include any general land use plan that's going to include people living there. I just want to go back to why I initially was saying that they could require paperwork. The way that this subsection 1 is written, it's almost kind of contradicts itself. It says it can't require notice, but then further down it says that property owners are required to obtain documentation. So they're required to have documentation, but they're not required to give notice. So is it notice on top of the documentation? Not really clear, right? So arguably, it's a question of whether a municipal government would require that documentation be turned over, and or whether what would have to be in that documentation.
Or are they just requiring the homeowner to do their due diligence?
Right, and whether that's part of the documentation. I would argue, if I were the city attorney, I would argue that it is that the city has the right to request that documentation, but they're not required to give notice. Arguably, that the notice part is, you know, what the statute is, I think, is getting at is that it doesn't require the city's blessing in order to remove a tree that's deemed to be dangerous. But I think that it would be a stretch to say that they can't, that the city is not entitled to the documentation. But as far as you know, residential is concerned, yeah, they can require a city can generally require performance standards on residential property, and so that might be a way for them to get around to eliminate the concern that this statute is going to be used for clear cutting by developers by requiring a certain number of trees per hectare, per square acre, whatever, however they define it in the ordinance. They still can do that. But what they can't do is stop the removal of a specific tree if that tree is deemed. But as far as residential is concerned, yeah, it's still going to be, and all of these uses, whether they're condos or apartments or subdivisions, is still considered residential. Should I go on to the second part of the question?
I have just a quick question, sure, clarification.
Sure.
So what you're suggesting then is if a particular local government has an ordinance dealing with new housing.
Right.
And it says on a single family lot, there shall be 2 trees of a certain type. The new law doesn't stop you from taking one of those trees down, but you're going to have to put another tree back because that ordinance already says you have to have 2 trees on that lot.
Right, and you see, this is where it gets kind of tricky because the statute says you can't require replanting per se, but you can require general performance standards, which says you have to have 2 trees on the lot. So it might be identical to requiring a replanting. The outcome's identical, but the mechanism under which they're requiring it is.
So do you specify a size requirement? So what lot you need trees of a certain size on it? Yeah.
Sure, you
I
could.
could do that. Shade tree.
Right.
So
Like an
go ahead,
acreage.
Norm.
Can I just ask a question? One of the questions we're getting at the chapter office is the definition of residential. Arborists don't want to make a mistake. And I'd like your opinion on what is it they can rely on as being meeting the definition of residential, I'm thinking it's probably the zoning.
Zoning, yes.
And so then it begs the question, what happens with mixed-use zoning?
It's gonna be the dominant use.
Okay, so if it's commercial, residential, and it's, you know, a tower that's housing, but there's commercial on the first floor, it's residential.
In all likelihood.
If it's an office building on top and there's one living unit in it or two living units in it, then it's gonna be commercial.
Yeah, it would be a case by case basis, but yeah, that's not exactly, that part's not exactly.
So I think I understand how it's going to be interpreted, and I can advise arborists accordingly. Okay, thank you.
Sure.
Jeff? Go ahead.
Second point, okay, so do they have the power to ignore the state law and continue with your existing ordinance? So no, they don't have the power to do that, they're going to have to comply with the state law. But like I said, there's some ambiguity in the statute as far as what they can and can't do. So can they require that the documentation be turned over to them? They're not entitled to notice, but they might be entitled to the documentation. So the question is, okay, they tried to make the argument that they're entitled to the documentation prior to the removal of the tree. That's going to be up for debate because they're not entitled to notice. So is it enough? Do you cut down the tree and then give them the documentation afterwards? They might be a property owner might be able to do that, or a developer might be able to do that. As far as like I said, the proofs, they can still require the proofs, but they do not. And I think I kind of addressed this before. They do not have the ability to ignore state law by any stretch of the imagination. And of course, they can't replant. But like I said, they might say that if you have to have 2 trees, and if you remove one, then by definition you have to have enough under code enforcement. But how would this work? The way that it's kind of in a way problematic without notice, saying they don't require notice, because the way that it would work is the city brings a code enforcement against the property owner. Then the property owner says as their defense, well, I obtained this documentation. So at that point, it would essentially force the homeowner to provide that paperwork over to prove that they actually got the required documentation from a certified notice. So then at that point, the city would have to make a determination as to whether they're going to move forward with the code enforcement through finding the homeowner, finding the property owner, or not. So that's where that would go.
Comments? Anyone?
I'll say our county attorney's office pretty much agrees with the inclusivity of the residential use. It's kind of consistent with our land development code. It doesn't differentiate between single family residential and multi-family.
I have a point of clarification, because I think this one kind of gets into some of the arbors too. It's like, okay, so you have an apartment building, and it's got trees, okay? And it's condos. Let's make it even more complicated. It's condos. Everybody owns the place, okay? One person wants to take a tree down, it's dangerous. Another person says, no, that tree's beautiful, I love it, that's why I want the condo.
Oh, so that's a great point. So Jeff, there's a special state statute. It's not positive. It deals just with condos, because condos are recognized legally as unique entities. They're like, where you have people that are sharing, either inches apart in terms of wall space. So the way that generally works is the condominium board would make those decisions, and by virtue of living in the condominium association, you consent to all of those decisions made by the board. So that would be for the condominium association.
Thank you. Emily?
Yes.
Please.
Yeah, I'm sorry I lost connection, and so I missed some of it, but I definitely want to speak on this. And maybe you addressed it, but I read this part of the code as a single family house, a small piece of land. It doesn't pertain to street trees. It doesn't pertain to buffer trees. It doesn't pertain to common areas. That's my interpretation. And I know as our chapter we did propose language for this that did not get accepted. But the language would have defined a single family, or would have defined it as detached single family or duplex residential properties of 1 acre or less. And I think that's where this big riff is going to be. You know, my house or my HOA's buffer. I mean, because that's not a person going to that buffer. That is an HOA. So that's not a owner. So I don't know if you address that, but that's my interpretation of it. And the other thing is, and start the conversation is, a lot of our communities, our residential communities, have HOAs, homeowner associations. Does the homeowner association still have the rights that are written in their architectural review guidelines? Do they still have the right to request notification of a removal of a tree? And then to deem it, whether, you know, per this code, they would say, okay, yeah, you can take it down. But then would they also have the ability, per what they're used to operating under, of requiring replacement? Because they are not a state agent. They're not a local government.
Well, the answer is yes, and it's by contract. So homeowner associations can essentially do whatever they want. If you don't, the way that it works, there's separate chapters for HOAs and condo associations. But the way that it works with them is they can have deed restrictions that require you to do certain things. If you don't do them, then they can bring an enforcement action against you. They can assess penalties against you. If you don't pay them, they can put a lien on your house and they can foreclose on your house. So they have a special mechanism of sort of forcing people, twisting people's arm and making them do things. And they'll continue to be able to do that. They can tell you what color to paint your house. They can do all kinds of things. And that's something you consent to by contract when you come into that homeowner association or condominium association. As far as residential property, I think that you make a good argument. But if you just look at the plain meaning of the statute, it says removal of a tree on residential property if the property owner obtains documentation. So let's say a condominium association that has a common area, or a HOA that has a common area, that is that residential property or not? That's going to be the subject of that could be the subject of conflict. So the way that it would work is, HOA cuts down a tree, and the municipal government brings a code enforcement action. Now, can the HOA assert this statute as saying, well, that we're a property owner of that common area, it serves a residence? Is that residential property? That's just not clear. That's going to be they're going to be fighting over that.
Yeah, and that's one thing that would help with clarity in the law, because, when we do a lot of zoning stuff too, and it is part of a residential community, but it is not a residential piece of property, that open space. It's where the playground is, or it's where the pool is, or so I can see problems.
Thought we had this answer.
Well, we knew this was going
I heard it different this time.
Yeah.
I thought it was going to be based on zoning. Zoning has distinct boundaries. So now you're saying maybe not, but I think it's going to have to be litigated to find out. Is that fair?
I think it depends on residential, this residential property term here. So the zoning is going to play a role. Certainly, if it's not zoned as residential, then it's probably not residential. But then you're getting more nuanced as to common areas. So as far as anything that somebody's living in or living on or owning, they can live on. But I guess when you were asking the question, I wasn't thinking of that dimension of it becoming a common area that's owned by an HOA or a condo association. Could that be narrowly taken out of this statute and say, well, that's not a residential area. That would be.
Well, they don't change the zoning map. The zoning map covers that property as well. It also covers habitats that are protected, any covenants, areas, those are also fall within that zoning designation. So I do think there's an issue with covenants because there are separate rules that apply to covenants. My concern is how do I advise arborists when they ask this question? And what I'm getting is we don't have a clear answer to tell them that if it's close to the condo, it probably is. It's far away, and what's that distance? I don't know. They don't know. And how do they advise their clients? I guess the answer is I can advise you with the risk, but as far as the application, I'm going to have to seek counsel.
And in fact, that's consistent with the, if you're not an attorney, you really are not held to, you're not necessarily going to be giving legal advice anyway. But yeah, they could provide the documentation. That would be up to the property owner whether they want to go ahead. But they could certainly say, okay, this is a hazardous street, or this is a dangerous street. Now it's up to the homeowners whether they want to take the risk and remove it or not.
So,
I,
go ahead, Emily.
well, I was just going to say, you know, you're concerned with it going back to the homeowners to take on the risk. I'm like consumed the other way, is the homeowner who wants to, the homeowner or a developer, if you're going to include more than a single family lot, who wants to basically clear stuff off. You know, it used this as an excuse to clear. And the
Yeah, that's the biggest concern from the city. I think Joe, you probably agree with that. That's the biggest concern from the municipal government side is that they're going to use this as a bad faith excuse, essentially, as a way to clear simply by saying something that it's dangerous, by having, you know, an arborist say it's dangerous, and that's not really why they're removing it. They're removing it because they're trying to build. So that's legitimate concern.
That would be a hard level to get to because there's, in order for there to be a risk, you have to have a defect and a target. And if there's no target, there's no risk.
Well, legally, they
So
don't
a
have
vacant lot could not have a dangerous tree on it.
But if there's property, I mean, like, it's like, yeah, Dave, I mean, it's people or property, so I mean, once you start getting construction equipment on the state, except the property, or, you know what I'm saying, like.
I think vacant lots with perimeter trees, those are the risks to adjacent properties, or I think that we deal with. But you put something in the center of the lot, that's no structure, there's no.
So there's a great deal of nuance here.
yes.
And a great deal that will need to be hashed out. And what's becoming quite clear is that the law is not clear. And so I want to go back so we don't go too far afield with all the nuance. And this won't be the last of our conversation about this law. But I want to go back to the other term that is very problematic. It's the term dangerous. I want to turn it back over to Andrew, who's our resident expert on the science of risk analysis, and ask if there is a threshold for danger that science can point to.
So, I mean, I'm not sure if science is the best term, but there are established thresholds for danger around the world. And even Norm and I were talking about this morning, the tree risk assessment BMP states a threshold in its definition of what's a hazardous tree. So in the old version, of the BMP. It's on page 7, and the new version of the BMP is on page 8. And it says a tree is considered hazardous when it has been assessed or found to be likely to fail and cause unacceptable degree of injury, damage, or disruption, or that is, it poses a high or extreme risk. So if you're looking for a threshold using this methodology, one that you can turn to in the BMP is on page 8 of the new one, page 7 on the old one. It is high or extreme risk. And you think there's 4 categories. It goes from low, moderate, high to extreme. You just look at a day like, oh, half the categories would be, potentially high risk. So that could be a lot of trees that get removed. But if you actually break out all the different combinations that you can risk assess, there's 64 combinations, and only one of them is extreme, leave you to extreme. And then there's only 5 that lead you to high out of those 64 combinations when you do this assessment method, right? So you have to get the right combination of target, likelihood of failure, and the tree's big enough to do damage to get to those levels. It's not like it's 1 out of every 2 trees can be removed based on this, And then to Norm's point earlier, a lot of the folks who worked on this risk assessment program, the track program, interpreted it as it's a communication, it's dialogue between the owner and the person, and so any threshold can be correct. But one of the creators of the ISA BMP, I was talking to him, one of the authors of this guide, and he kind of falls in line with that extreme, that high, and some of the comments they sent me, which makes it seem like this was not an accident that this stayed in the guide. We wondered why is that word defined in 2 different versions of this document. So abroad, they use thresholds all the time. And in the UK system, the quantified tree risk assessment method, they use tolerance of risk, the TOR threshold. And what that is use medical terms, like a 1 in 10,000 chance or a 1 in a million chance of a risk of harm. So for their method in New Zealand and Australia and the UK, any risk of harm is considered acceptable and not a worry. A 1 in 10,000 risk is considered tolerable if mitigated in a reasonable manner. Anything below 1 in 10,000, you can't impose that on someone else. Like you can accept it as a homeowner, but you can't impose that on someone as a public entity like a county government or a city without some sort of consent from them. And so that is being used around the world, right? So it wouldn't be a stretch to have a city or a government have a threshold. There's people have done this before, whether or not that'll hold up to something for someone like Jeff to answer, But cities can define their own thresholds and there is a basis for that. So,
Comment? This is a science-based model. Certainly the high and extreme risk would be the most desirable realm to consider a dangerous tree and the most defensive.
And as I mentioned before, we did risk assessment, doing the risk assessments before Hurricane Matthew, and these are the ones that were most likely to get right because they're things you can see, the really visible defects for visual risk assessment.
Jeff, anything from the legal standpoint?
Yeah, I think it goes back to what we consider to be acceptable risk. It kind of gets getting into basic negligence theory. It's what the burden placed on someone to prevent harm is based upon the relative likelihood and consequences of that harm occurring. So, if there's something that's extremely, the example I always give is if you take your child to school or to daycare, they get struck by lightning on a sunny day. But yes, that's possible, but it's so unlikely that if it were to happen, there would be no negligence. It would just be a freak accident, so to speak. Versus if you had kids playing on a stormy day with lightning, or whatever the case might be, or driving with bald tires, or whatever exist. So, like Andrew was saying, you know, what level of risk that you impose on somebody else is going to depend on what the society accept as a whatever risk is reasonable. But of course, that's a subjective standard, varies from person to person. So that's always difficult to determine.
Jeff, for point of clarification, Andrew mentioned several different ways of assessing risk, or quantifying it, or describing it.
Yeah.
Within the statute as it stands today, can local governments dictate to certified arborists and licensed landscape architects of which form, methodology that they would need to use?
I don't think they can, because the statute says as determined by the arborist, right? It's exact language is obtains documentation from an arborist certified by the International Society of Arboriculture that the tree presents a danger to persons and property. So I think that a fair reading of that statute would be that the arborist gets to decide which method they're going to use, not the county or city. And so that's, I mean, that they could try, but I think that if it went to court, they probably lose. And so if the arborist used a different method than that preferred by the municipality would have to say.
Then using the example that Joe brought up from the city of Tampa, which now has an ordinance that describes a dangerous tree.
Yes.
And it uses a methodology that, you know, is part of the industry anyway, but they need to apply.
Yeah.
So what you're saying is that if an arborist or a licensed landscape architect comes in and says, I did this assessment, it's a dangerous tree, the city of Tampa can come back and say, well, our ordinance says that a dangerous tree is described this way, and you're not describing it in that manner.
Right, and in fact, not only that, but I believe that they would have to take down that ordinance, and I believe they already have. I was looking it up the other day. I couldn't find that chapter 13. I say would have to actually remove that because it would be in direct conflict with the state's.
Can I interject and ask a question? Okay, so an arborist was hired or a landscape architect, and they wrote something and determined that these trees could come down. The municipality says that doesn't look right. Is the only way to get through this, if the city truly believes those were taken down and not correct, it would be through a lawsuit?
It would be what it would be is through an enforcement action. It would be through a code enforcement. So they would have to assess a fine, and then the developer would have to challenge that in court.
So there's no easy way, because, and you won't find out till way down the line whether, you know, the criteria used for dangerous will hold up.
Right, and that's the thing about our you know, it's one of the frustrating things, but it's kind of, you know, how our judicial system was set up. And Article 3 of the Constitution is that, you know, the courts only concern themselves with what we call cases and controversies. So it would have to be a live controversy where you have an actual imposition of a fine followed by an appeal of that fine in order for them, the court, to hear it. The courts are not, don't have jurisdiction to entertain hypothetical questions. So it would actually have to be a real case that was a real conflict that made its way into the courts. It's kind of sometimes not a pretty way of doing things, but that's how we get that's how the law is made, essentially.
And would the person, let's say that the city didn't have a problem with it per se, but this report, which was used to justify cutting down the trees, it really doesn't go to anyone. It just is there in case someone says it doesn't look right. Is that correct?
Correct. It would only be there as a defense to an enforcement action. That's how it would. That's what we anticipate that probably will happen. But yeah, if the city's okay with it, they can always it's kind of like a, you know, if a trooper sees you speed and they don't pull you over, they don't pull you over. I mean, it's you know, they're okay with it. They're okay with it. It's where the conflict arises if they're not okay with it and the homeowner, the property owner asserts this.
Yes.
You got a comment?
Nope. Yeah.
So we're going to move on to the last question of the session. It starts out with Emily and Norm. And the question is, should certified ISA arborists and licensed landscape architects who are found guilty of false reporting have that evidence submitted to ISA or to Florida DBPR for consideration as a violation of the certification or license?
Who wants to start?
Go ahead.
Okay, I'll start. In our state statute, it clearly states 481.325E, making or filing a report or record that the licensee knows to be false, willfully failing to file a report, etc., has disciplinary action. And in our rules, there are a couple rules that are noted potentially for something like this. And one is the filing of a false report or failing to file a report as required. And it can go anywhere from a 1-year suspension with 2 years probation to revocation of our license and a $1,000 fine. There's deceptive, untrue, or fraudulent representation in the practice. And that could be a 1-year suspension and 2 years probation with fines up to $1,000 also on that for the first offense. Intentionally violating any rule. I would expect that we would probably have some rulemaking in our law that addresses this, because we do for mangrove pruning. So I would assume that the same thing would happen here. And is that the last one? Yeah, I think that was the last one. But so I see lots of places, yes, and the way it works for us is that someone files a complaint through our board, and it's investigated privately. And there's also, if you're an ASLA member, there's also ethics that could be dealt with on that level too. But this directly affects our license. So we have a vested interest not to do wrong.
Thank you, Emily. Norm?
So ours is very similar. Ours depends on what you are. If you're a certified arborist, then you are covered under the Certified Arborist Code of Ethics, and the penalties and the investigation process is very similar to what Emily just talked about, with the exception of the fines. You don't and can't give out fines or levy fines, but you can lose your certification for an indeterminate amount of time based on the severity of the violation. So then there's another one for master arborists. The penalties are more severe for BCMA, the master arborist, for violations. But again, it's not a fine. There's an investigation and a determination done by a panel of your peers, and they decide how long your certification. And basically what we hold our credential holders to is the standard. So for example, in the United States, we have ANSI, American National Standards Institute. We have various standards for risk assessment is just one. There's standards for pruning, there's standards for planting, there's standards for fertilization. Many aspects of things that arborists do. There are standards written that you're expected to follow. And if we discover that you didn't follow the standard, then you're held accountable.
Thank you. Jeff, a point of clarification to this is we've just asked the two representatives of the professional associations how they would, how it would work within their associations. What about violations that can be proved, which would be interesting enough? Question. So, relative to the government, will they actually be able to prosecute for falsifying reports, or is the law so ambiguous that falsifying a report is not even capable of making that judgment?
Well, you would, I'm not sure that there would be any criminalization of falsifying this report per se. As far as the landscape architects are licensed through the Department of Business Regulation, and that's something that's subject to a series of laws that govern state entities like the Florida Administrative Procedures Act, Florida Federal Freedom of Information Act, and other things. And maybe Joe, you can jump in on this as well, but my understanding is that the concern with some municipalities is that ISA is not part of the government per se, and although the current board running it, I'm sure there's much faith in the future hijack of something else, and it would be part of something that might be very much, not punishing wrongdoers per se. So that was a concern. Actually, do you have any thoughts on that?
It's an interesting thought. Everybody assumes that you're going to operate at a high ethical standard, but with a nonprofit, you really don't know, do you? I think it's a safe bet that right now I serve as the chair of the Credentialing Council. One of the functions the Credentialing Council has is the oversight of code violations. We have a separate group that deals with that. I have every confidence that group right now will do their job at a very high level, but you really don't know, just as we don't have confidence in state government doing their job at a very high level. So it goes both ways. It would be fair to say.
And just to walk this just a little bit further down the line, not so much from an ethical standpoint, but from the perspective of local governments, and perhaps having some influence over what happens. I've gotten several questions addressed to me from municipal and county governments talking about, well, maybe we would issue business licenses to arborists. And in the business license, we would require that you follow certain rules or regulations that pertain to the assessment of trees. And that if the assessment of trees was not done in accordance with that business license, that we would remove your license and you would no longer be able to practice within our municipality or within my county. Is that something that could happen relative to this law, or does this law preempt that from happening?
So essentially, it preempts it from happening with respect to arborists, but not with respect to landscape architects, because that's still the case with landscape architects with license. And maybe Emily, you could expound on this a little bit, but I think that is true for architects, probably not for artists.
Okay, so currently landscape architects are licensed by the state. And we also have occupational licenses for the county and the municipality we work from. I think it comes up to being a problem when I'm operating outside my county and outside my town for me to go get another license there. So it's doing is saying I have a license to set up a business as a landscape architecture firm in Jupiter. It's not saying that, we're relying on the state license for that. Now, it's probably a little more difficult with the, someone needs to put their self on mute. It's a little more difficult with with the arborists. But I think that irrigation certification is going through the same thing. How do you get the equal certification or acknowledgement across the state rather than, you know, individual communities?
Thank you. We do have one question, and I apologize that I skipped over. It's important. Norm, had a comment?
Yeah, just a quick question actually for Jeff before we move on. So it's my understanding that if there was going to be a penalty phase of this law, they would have put it in this bill, or does section 163-045 have a penalty section that might apply? Is there what they put in 163-045? So I'm looking deeper into 163-045. There may be a penalty section discussed.
I mean, a penalty for
Violations of 163.
oh, for, you mean if the violations if the municipality.
Could be either one of the violations.
Well, that's a way to violate. Well, 163 is, it protects the property. It essentially, it provides, it limits the, what the municipality can do. It doesn't limit what the property.
Okay, so this is the beginning and end of 163 is what you tell me.
As far as relates to trees.
Thanks. I do want to say at this point, just about that there were many questions concerning the role of state government in this and the oversight of this by the state government, since it is a state statute. And of course, we do not have that expertise here to answer those questions, but we will farm them out and try to get answers. I did skip one question, and I apologize for that, and it's an important one. Another one, of course, like all of these that have been sent in from you to ask the town. And I'm going to address it to Joe. How is a tree being defined? Many argue that palms are not trees, and of course, technically they're not. A tree, according to most definitions. So could a government therefore regulate palms?
So I guess the crux is within palms not being part of this. As it stands in Hillsborough County, our definition of tree in our land development code references palm. And as importantly, the lists of trees, like street trees, ornamental trees, is inclusive of palms too. So it would be disingenuous for us to somehow try to exclude palms from the intent of the statute, at least for our jurisdiction. This is where I have to emphasize again, this would be the type of thing you would consult with the jurisdiction that you're working with to make sure they view it the same way.
Comments?
You know, I have a comment totally unrelated to my work as for ISA. But I was surprised to hear you say that palms, under most definitions, are not trees. Because I think they are. I think, you know, most definitions are it's a woody, self-supporting plant, able to grow at least 12 feet. I mean, some people would say different heights, but it meets all of it. So my experience has been that palms meet the definition of trees that I've seen in all of my 40 years.
Yeah, I would agree with that. If you look at a textbook definition, it's usually like a tall growing woody perennial, long-lived woody perennial with an elevated canopy. And it doesn't say anything about, you know, how many cotyledons were present, it's like germination or, you know, what the vascular system is
They
made
have
of.
at least two.
Yeah, not one monocotyledon. Yeah. So.
And when you're designing space, you know, they fill the space the same way trees do. I mean, you know, they have trunks and they have a canopy of some sort. So
I put this then, I still disagree with you. That's a common way of defining it. But technically, if you
It's a grass.
Recently, whether they were trees, and they would say no.
Yeah.
Grasses.
So they're grasses. And so I would ask Jeff, given the fact that a truly technical definition of a palm is not a tree, does this law apply to palms?
Well, I think that would be interesting. I would enjoy watching. I would love to explain to the difference between them. I would enjoy that thoroughly, but I think that what they probably fall back on the sort of everyday use of that term, how it's defined in legislative intent. So I think they'd be hard pressed to come up with with any type of reasonable reason why you would exclude trees, why would you exclude palms from trees based on its classification. So I think that I could see a few judges probably just saying no.
Okay, so we agree that taxonomy is not likely to fall within the purview of the judicial system. Okay.
Well,
So-
and there's, and just one other consideration. Can a palm cause the same kind of damage to property as a shade tree? I think the answer is yes, depending, on all considerations. So it still is.
Of a palm that cut a house to the foundation.
Whoa.
So, yeah.
Okay, so therefore it should be part of this from that point of view. They are just as much or a different kind of liability, but it's still a liability.
Thank you. We have just enough time for each of the panelists to take 2 to 3 minutes and wrap up any comments or ideas or more questions. Sometimes I think we generate more questions by doing these types of discussions, but this is the place to start. So again, I want to start with Emily, our remote panelist. And Emily, got 2 to 3 minutes of ideas, comments you want to share?
Yes, thank you. Thank you, Rob. I would like to offer to my other panelists and anyone else who's listening that I'm going to put forward that ASLA will work with anybody to help create some glitch code amendments to this if we all feel it's beneficial. And I think after what we're hearing everyone say, we've got definitely some issues. I think clarity would help and some definitions would help. What is residential? I'm glad to hear that the HOAs probably will rule in this and they are not considered local governments. I am concerned, I'm just concerned with the abusers of the code. You could take ag land that allows residential and a big tract of land and it has a house or two on it. And they use that somewhere to clear the land basically, and then build a development on it, so I would, and the problem is even if it's done under false pretenses, once it's done, it cannot be redone. We cannot get it back, at least for another 50 years. So just really concerned with this bill. And that I would caution any landscape architects listening on this. There's a lot of ethics that you're going to have to be concerned about that we don't always deal with in our business, and to be very careful. And I support us moving ahead to clarify anything we can do on this. Thank you.
Thank you, ma'am. Norm, you want to take the next one?
Yeah, the Florida ISA Board of Directors has had an opportunity to have a meeting since this bill passed. We've formed a task force to look at all the measures that Florida ISA can take to help our members. And some of the ideas that were discussed is to begin a public awareness campaign to help the public understand how resident tree is assessed, and mostly how they can use our industry, our certified arborists, to help them with this assessment process. They also want very much to go after the certified arborist impersonators that are out there. This bill has caused several to pop up, and we want the industry to pursue them aggressively. The chapter is going to help our members with that. The ISA has a imposter program that they enforce very diligently, and we're gonna work on helping our members with that as well. We also want to start. We talked about starting an ethics education program to help our members make the decision to decide whether or not they have the ability to do risk assessments on residential property. Earlier, I talked about what it takes to be a certified arborist. You need a broad level of information, but we don't take a deep dive into the arbor certification. And then if they want to know more about this issue, that they can get our track credential. Right now, there are over 300 track credentialed people throughout the state of Florida. It's about 340, I think. And there are about 2,000 certified arborists. So we're going to help them make this decision whether they feel they're qualified to make these determinations for Florida residents, or whether they need more knowledge.
Yeah, I know I sound like a broken record, but the fact that this law is unclear as it is really a pretty sad thing to think about, because it's absolutely predictable that there's going to be hundreds of thousands, if not millions of dollars spent on attorneys' fees and court costs fighting over this, when this could simply have been clarified so that we all know what's going on. Also, the fact that we have such outstanding experts on free risk like Andrew that simply called you and asked if the subcommittee could figure out how to more artfully draft some of this language to avoid this ambiguity. Sometimes it's not even sometimes even as important or more important than what the law is that the law is clear, that everyone knows where they stand, what they can do, what they can't do, because when it's ambiguous, it's going to lead to problems. So, hopefully in the near future, this won't be clear. Andrew?
We talked about how, it's really hard for local governments to kind of police this and see that, you pretty much, it's after the fact, hit the mostly beforehand. But to Norm's point, I believe there'll be a lot of industry with it. If someone's shopping around for arborists that'll give them the rating that they want, then you have other people that have risk assessed that tree already, and that'll come. Those kind of situations will come to light, And we're watching this. We don't. Some people were fairly pessimistic about the outcome of this. Maybe justifiably. Some people don't think it's going to have any input back because people love trees. I've heard all sorts of through that whole spectrum, right? But we're going to be watching this. We're working with Florida Forest Service. We're going to be doing canopy analyses for all the metro areas in Florida and most of the major cities. And we'll be watching this. We'll have our line on the ground, our baseline data this year. We'll see what happens in the future with this. So,
obviously, we'll be watching too. And honestly, we kind of view it as business as usual, at least for our jurisdiction. And these dangerous trees really should represent a very small percentage of trees that we encounter in the urban forest. We've long recognized the expertise of certified arborists, and years ago established an accelerated permitting process so that you submit information about it, permits issued. So if there's ever a doubt, for a $35 permit application, you can go through the normal channel that it always has and avoid the potential that, as it stands now, the call is made tomorrow that a tree has been removed without a permit, expected species. We're going to go out and we're going to be looking for, if they're claiming it was dangerous, documentation that was provided in advance to the homeowner. They think this was a dangerous tree. If it wasn't, our enforcement mechanism continues on as it always has. So that's again, safest option probably is to kind of go with the process you always have. And I can again re-emphasize, check with each jurisdiction you're working with, and might have another take.
Thank you. Thank you all. This has been really great. Good number of questions raised, some of them answered. Emily, thank you for participating from the East Coast. Thank you all for checking in, listening to the panel, and submitting all those questions. I'm going to ask you through email to keep submitting the questions as they come up so that we can keep addressing this change in legal status of tree removal in the state of Florida. We're going to end this recording now and end this webinar. But for the folks who are here in the audience, we could stay just a little bit longer and answer perhaps some questions if you didn't get your questions answered. And again, I want to thank everybody out there, and I want to thank you all for caring about trees and forests. There's not enough. Bye-bye.